from, pardon me?
Oh,
She's not here, okay. All right. Ring her in? You could. Now, we've got the defendant here. Good afternoon. First thing we'll take up is the Law and Crimes Rule 22 motion, and I have signed it on condition that no juror or potential juror at any time be recorded in any way, and otherwise you conform with Rule 22, any violations of Rule 22, or if a juror or potential juror is recorded in any way, the court may remove or exclude Law and Crime TV from the courtroom. We'll go with that. I have one question. Is this going to be a live feed or is this recording? And the reason I'm asking is so I can tell the jurors if it's a live feed to tell them don't watch TV.
I don't know exactly when, but they may take it live at any time.
Okay.
So it is going back to them for them to record it, but they may actually break in live depending on where we are.
Okay. Okay. Well,
I would treat it as live.
okay. All right. Thank you. Clerk. And with that being said, just for my benefit, if, well, Ms. Goble, you were not in the courtroom at the time it was mentioned. Now, I'm assuming your attorneys have told you I'm a senior Superior Court judge. My name is Joe Bishop, and I'll be presiding over the case for the next couple weeks. And with that being said, if you'll just tell me who you are. I think I kind of know from the Zoom session we had, administrative session we had a couple of weeks ago, but other than that, just kind of tell me who you are and we'll work from there.
I'm Amber Dally. I'm the Chief Assistant District Attorney here and one of the two people who will be trying the case.
Bailey Wilkinson, Deputy Chief, ADA, and will also be co-chairing myself.
Good afternoon, Your Honor. Attorney Ben Sheeta. This is Attorney Olaloye, and we'll be defending Ms. Goble in this matter.
Okay.
Nice to see you again.
And as I understand, we're here today because of the state's motion in limine, and I think you all have filed a response or a motion for rehearing the earlier in limine that Judge Wynn granted several months ago. But I think they'll all kind of be tied together. But you may proceed.
Okay, Judge, our motion in limine, I think actually us and the defense are pretty much in agreement. They can let us know if there's things that are, I guess, that they are really contesting here. But when it comes to the character evidence that we're referencing, there's lengthy interviews given, and in those interviews of the defendant, she talks about the co-defendant and things that are just obviously bad character evidence, like he stole copper wire and AC units before, and that has nothing to do with anything in this case, or that he, used used drugs or whippets and was passed out under a bypass, and she found him one time, and that was before they even lived at the residence where this occurred. So there's things like that that I just, all the stuff that she talks about, him, her knowledge of him being violent, her being afraid of him, her, all of that kind of stuff, we're leaving in. I mean, her interviews, I'm not trying to change the essence of the interviews of her defense, just the things that are so clearly bad character evidence and serve no purpose, have absolutely no probative value. That's what the state is asking be redacted and removed essentially from the interviews. I've actually gone ahead and I have copies of all of the interviews that I have tabbed where I think the state would want redactions, and I've tabbed even where I think the defense might want some redactions because there's some drug use referenced on her end. We may need to have a little bit of discussion about that. So I have copies of those I can give to everyone, and we can go through that if we want. I've tried to kind of get a little more guidance on their opinion on some redactions, but I don't know specifically where they stand. I haven't gotten, a yay or nay as to any specific information, I guess. I think we can work through that, but it's not that they're difficult to work through. It's just, I think, a lot of interviews to kind of discuss. But we're not really asking for a lot here. We're just asking that the obvious character evidence, like him having prior thefts and him having these sort of drug habits or drug incidences that aren't directly related to the murder itself, be redacted. If he were to testify, obviously then he could be cross-examined about prior felony convictions. But that's a big if, so I don't know, really. So I'm ready to do that with the redactions if we want. I think that everyone can rest assured then they would know what is being redacted or what, we may need to discuss further. I think that moving through the motion in limine, that addresses really the first two. Moving into, that addresses number 1, and then A, and then going to B, which is specifically refraining from the defense introducing a mental health diagnosis and treatment of Jonathan Warren. We are in agreement that when the victim, when Ms. Goble and when maybe other witnesses talk about lay testimony of he was delusional or he was crazy or that can all come in. I think people's observations like that. But in terms of specific diagnoses or treatment, there's not going to be any psychiatrists that testify about that. It has no relevance here, and it would all be hearsay information. So that's just what I wanted to address and make sure that we're not getting into any kind of psychiatric diagnoses or anything along those lines. I think they're in agreement with that.
No objection. We're cool with that.
All right, so they're good with that one. And then obviously refraining from eliciting testimony or evidence about his guilty plea or his sentence if he does not testify. If he testifies, clearly fair game. I think they agree.
The law's clear on that, so unless he testifies, we don't intend to.
Okay. In that vein, let me inquire. I haven't looked at the documents, but the indictment or what has been done in terms of redaction of the indictment with respect to co-defendant, if any, and if it has been done, has defense been aware of it?
If they're charged together, I honestly don't recall whether or not they're on the same indictment, but if they are, we can create a dummy indictment before jury selection even starts, and it can just list her.
Okay.
Probably in an abundance of caution if everyone's comfortable with that.
I just want to make sure there wasn't an issue there. Okay.
Yeah, and I think they agree, none of that would be mentioned in opening then, because we wouldn't know how the testimony would go.
That's correct.
Okay, so we're on the same page there. And then the evidence regarding her mental health or victimization or things along those lines. Again, stuff that she discusses in her interviews that she's been diagnosed with or that she feels as though she suffers from, not redacting any of that. How she talks to them, we can leave that there. But I just mean that if she takes the stand in sort of these diagnoses about PTSD and things like that, case law is clear that the defense isn't claiming she's incompetent or that she's insane, that kind of information isn't relevant, that really isn't supposed to be proffered. So I just want to, I think we're on the same page,
Yeah,
okay?
that's
So we don't really need to debate that one.
Okay.
All right, and then the last one, they've told me they are not proffering a battered person syndrome defense in any way, so we don't probably even need to really address that. I'm sure with the experience level that they have, they're not going to bring up sentencing at any point in time, and so we're not going to discuss that. So I think we're really on the same page, and we just have to kind of maybe iron out a few of the redactions.
All right.
And then, well, along those lines, I want to say, just real quick, so if that's all we're left with, when it comes to their motion for reconsideration, Judge, I have some case law I can give to the court. If it's outside the term in which it was decided, the trial court really is not supposed to reconsider motions unless there's literally new evidence, new facts, something that requires that to be sort of reevaluated, and that's not the case here. I mean, there's just nothing that's different from what it was when Judge Wayne heard the case in October and when he made the ruling in March, and we are outside the other term. So I think I think that they would like a fresh set of eyes on it, is sort of how it was said to me. I understand why they would like that, but I don't think that that's really a legal reason in which to go down this hole on the English trial, basically. And I have some cases I can present to the court if you would like.
Okay, well, let's hear what they have to say, and then we'll worry about rebuttal. Go ahead, sir.
Yes, Your Honor. So we agree with the state on the things about redactions.
Can I get you to move the microphone over
I apologize.
in front of you? Thank you.
She did tell me I apologize. Yes, Your Honor, so we agree with the state on the things that need to be redacted. There's one thing we need to speak to the state as well that we would like redacted. I do have that title under one of the interviews. As my client, she spoke to law enforcement, but when she hands over the phone, there's some things after that a different party speaks about. I don't think that's relevant to this matter. So we'll be seeking that to be redacted, and I can talk to you guys about that as well. When it comes to our motion, you look like you have good eyes, Your Honor, but we're gonna withdraw that, so that's no issue. If anything, we'll make our objections on the record to preserve that.
Okay. Can we quickly look at whatever it is that you want redacted,
Yes.
I guess, in your transcript, and that way you'll know exactly what it is, and we can
Here's my
resolve that.
copies with tabs, because there are several interviews here. Would you like one, Judge, to follow?
Oh, yes.
Okay. You want one, Caleb?
More than likely, this is going to end up in Michaela's hand.
Okay. And the interviews are in chronological order in the packet.
Is this my copy, or is you want?
Yes, no, y'all can,
Appreciate it.
you can have that if you want.
Did you say you said something about an order in the back?
So the different transcripts are in chronological order.
Oh, they're in
of
chronological
the
order.
interviews.
Okay, okay.
So the first one is her phone interview with the Atlanta Police Department on March 16, 2016. The only thing I say redact here, what I mean is I think we should stop this interview, this may be what you're talking about,
Before
but
Mr. Brown.
on page 8, sort of at the end of the conversation, right there where, basically right after the last Goble, because the rest of the interview is just the officers talking to each other. Is that
That's what I
you-
had written down, yes, thank you.
I have that as well. So that one we're on the same page about. I'll write a check mark and make sure that works. Okay? The next one is the interview with Terry Feely on 7/10/2023, and I don't see any redactions needed in that one. So y'all can let me know if there's anything in there that y'all see, but I didn't even flag anything that you guys
No, we
might
didn't-
have of
We're
interest.
good on that one, Your Honor.
Okay.
And then,
And feel free to take whatever time. I mean, we're no major. I don't want you to feel like you're rushed.
Thank you, Your Honor, appreciate that.
the next one's the interview with Ashley Durham, 7/10/23. And the first redaction I have flagged is page 3, and it's from, I think they're all highlighted on y'all's, right? Okay,
Yes.
so you can see it, page 3 into the first line of the next page. And that is just because that entire conversation is really Ms. Goble talking to her children about a boo-boo, and it just has nothing to do with any of the case they're talking about, facts of why or not. It's just her interacting with a child, and I think it's prejudicial just to leave that in there for that one.
Okay. I'm assuming these are videos of somewhere,
So-
and you're intending to tender them as a audio video document.
Thus far, the ones we've been talking about are only audio. They're
Okay.
just audio, but the ones after this are video and audio.
Okay, and so you know where in the audio to stop it and skip to, or have you already just deleted that?
I have some amazing staff that figures out how to splice it together as
Thank
best
goodness.
as can be.
I'm
Yeah,
glad
I
you're
don't
not
know.
depending on me to do it. That's good.
And if it is obvious transition or issue, I may ask the court to just give an instruction if we feel like we need it. We're usually upfront with jurors and opening, like sometimes we have to redact things, you know? But if we need an instruction, I've had judges before say essentially, at times the parties need to redact information that is prejudicial, or, you know what I mean, this is in the interest of both parties and da-da-da. So maybe we need that, maybe we don't, I don't know yet.
Okay. More than like that, we just tell the jury that at this point, in order to shorten the interview, there's some matters that are irrelevant, and then
Okay.
we'll move forward. I don't want them to read anything into
Okay,
action.
so are y'all?
We're good with that, so
Good with
now
that,
on
okay.
page 7, I believe.
Okay, yes, so we're good with that, let me check mark that. So page 7, I think that's the same exact thing, it's just the conversations with the kids about swimsuits and pajamas and stuff. Or something like that.
Okay with that.
Okay.
For 13, we read it and we're cool with that. Is that because the whippets and the...
So page 7 you're good with, and
Yes.
then you went to 13 and you're good with that too?
Yes.
Yes, because that's just kind of a general drug use thing, it's not, okay. I think the next page was 22, and that is, I think, well, both, a past drug use and children talking.
That's the speaker finding him in the river.
The river,
I
right.
hate that, so let's speak up.
So, we're okay with that. Okay with that.
All right, the next one's the bottom of page 24, and again, it's just conversations with children. And the same with 25 and 26, to be honest.
We're okay with that reduction.
All right, we'll move on to page 28, which is the same thing.
I think 26.
Oh, I thought you said, okay, 26, yes,
Same.
it's the same idea.
Okay, so we're cool with that as well.
Okay. And it goes into page 27, and then there's a little bit more on the bottom of page 28. I think that's it for this.
We're fine with that, Your Honor.
interview. All right, so the next one is the interview on July 11th, 2023 in Peoria. In the first page I have tabbed is page 13. At the bottom of 13, there's some discussion of him stealing the copper wire. And then I put another tab with a question mark at the top of page 13 because that's where I think she begins talking about, or wait, no, that's just her, yeah, well, it's kind of both of them. She talks about her doing heroin and then him taking triple C's. I mean, I'm interested to hear what y'all have to say about the heroin. I would like to leave in, I think it should be left in that she says she does heroin because she talks about doing heroin at and around the time of the incident, basically, at least would have been leading up to it, that she would have theoretically been doing it. But I think more importantly, want to leave it in because I don't think it's true, and I can disprove it with other evidence, so it's just another
remind me again, which page?
13,
13
yes.
of the,
It is of the transcript with, it says interview with Katelyn, July 11, 2023.
Okay.
It's top of the transcript.
maybe, not the interview with Ashley Durham.
No, we're done with that one, Judge.
Okay.
An agreement on everything there.
This is the one where there's green, you got different color tab, I think you have a blue tab, or is that green?
Yeah, green and,
Green, okay.
English, salmon.
The green tab I noted for ones that they may be arguing, and that is her heroin reference. And there is actually some information simultaneous to it about him using the triple C's and the cough syrup, but I didn't know what they wanted in terms of her discussing her heroin use, if they feel like that's part of their defense as to what was going on, or if they wanted it out. I kind of want to leave it in, and I think I just explained why, but.
Your Honor, we would ask that it be left out. One, we don't think it's relevant. She's not charged with any drug-related crime there, so we would ask that specifically any mention of her taking heroin again, because she's not charged with any drug crime, we don't think it's relevant for this case. There's no mention that drugs were related in regards to the actual alleged killing there. So we would ask that the mention of Ms. Goble taking any heroin be also excluded and redacted from the agreement.
And we're talking about the first 9 lines on 13,
Correct, Your Honor.
down to MJ, okay.
Yes, Your Honor.
Yes, Your Honor.
I mean,
Yes,
if we did that, I think it would be everything basically on that page until she says, yeah, and he also told me he got arrested before providing a girl. But again, I just, the heroin is something she discusses as to why she was so unable to leave the defendant and stay in Georgia, and as to what was going on at around the time, why she doesn't remember specific things that they're asking her, because she says, I was using heroin. So it's really intrinsic to the murder itself, her memory of the murder, the reason why she would have stayed with the defendant. I mean, that's how she describes it. And again, it's also not true. And there's a lot of evidence that will suggest that that's not true. And so if she's lying about that and trying to place herself in that position to look vulnerable or like a victim, or why she, you know what I mean, to kind of put that argument out there, because this entire interview is her saying, yes, I helped dismember a body, or interviews, but I had to, and he made me, and I was dependent on him, and I was under his control. So if I can disprove that reality that she's saying I'm this heroin addict there, that's actually very probative for me to do.
The argument would be, Your Honor, from my review of the evidence, that's not her big assertion at all. Like the state said, she said under his control, 19, no family there, all under his house, he's abusive, etc. Even the day that this alleged to have occurred, she stated, I believe to Downs, that she didn't say nothing about her being on drugs. She was tired when they did the drive, etc. So there's no, the actual day that this occurred, there's nothing that's stated about her being on drugs or taking heroin or anything. Actually, what she states is that I think the co-defendant asked them to get drunk. That's it.
So State's asking to redact what's in the orange highlight. And you all are asking to redact
The whole
the
page,
entire
if that's
page
the case.
13.
Yes, Your Honor.
Yes, sir.
Okay.
And I just, to provide context, throughout the course of these interviews, she's going to talk about heroin a bunch more. And she's going to talk about, I've been sober for 7 years, which is also not true. You can see everything, using other substances and drinking and everything throughout her records. So I want to be able to show that she is lying. That is important for these interviews, to show that she is not truthful. So she is lying about drug use, she's lying about sobriety, she's lying about all of that, and there's reasons for that. I mean, it's because she's trying to place herself to be looked at in a certain way at the time this was happening. And she was using heroin at her around the time of the murder, because she says later in the interviews that she uses heroin when she works. When she would go to the strip clubs and everything, she would use heroin. And you know what I mean? And so I think that she for sure would have been working the day before the murder, leading into it, because that's when they have an audition together with the victim at a strip club, just based on her own contention about when and why she uses heroin itself. She also tells other people things that aren't true about heroin later after this occurs, like other boyfriends, that actually Alexander Ward was a heroin dealer and all of this stuff. So if any of that's brought up also, I mean, this is just, she's made it very intrinsic to the case and her credibility.
I'll last word, and then I'll make a ruling.
Your Honor, none of that is relevant. This is not a drug-related crime. She wasn't charged with anything drug-related. And even that speculation to say that because she stated it in one interview, then at the time where she worked prior to this incident, she was on drugs there when there was nothing that stated that. So we just asked for that to be redacted as well.
Well, we'll redact the entirety of page 13 down to, and I'm not sure where, the defendant responds, yeah, he also told me he got arrested before for biting a girl. That wasn't highlighted. But I'm not sure where to pick up on 14 is what I'm saying. But I'll grant the request to redact 13. And obviously, if she takes a stand and testifies differently, then you can ask me to revisit this portion of the motion in limine.
I didn't redact the bottom of 13 when he said, and also he told me that he got arrested before fighting a girl because I figured that you would object to that, and I don't really care.
Yeah, it doesn't matter. It wasn't against her.
So
So we redact that too?
So, are you asking to redact that or not?
Yes, well, I am now.
We got a moment, Your Honor. If I got a
Brief
moment.
moment, Judge.
Sure.
Yes, Your Honor, we would like that to be kept in.
Okay, so from the top line of page 13 down to to get like the materials out of them inside question mark is to be redacted.
That's correct, Your Honor.
All right. There's nothing else in that interview.
I don't think so, Your Honor.
Okay.
Yes, I think that's all for that one. So turning to the August 2nd, 2023 interview on page 16. I'm sorry.
I just want to make sure you all had an opportunity to look through the rest of the July 11, 2023.
Yes, Your Honor, and at this point, there's nothing.
We're good with that? Okay, so we're moving on to 8/2/2023.
I have on page 16, it's more of the AC unit stealing stuff.
We're good with that, Your Honor.
Okay.
Page 19, this is another, it's both the scrap metal discussion and unrelated drug use.
We're okay with that, Your
All
Honor.
right.
And then page 28, just a couple lines there where she's referencing the same things at the bottom of why he got kicked out of his parents' house, according to her.
That's
We're
fine,
good
Judge.
with that.
Page 32, it's just that first line, talking about him getting high in a parking lot one night.
We're fine with that.
And then page 33, same thing, just whippets and triple C's and buying them with her money.
We're fine with that, Your Honor.
Okay.
Bottom of page 38 into page 39. This is, I think, the same river
It's the
incident
same.
that she saw.
Yeah, we're cool with that. It's the same reference.
Okay, and then on page 43, trying to, just look at this real quick and try to remember. this is where she's saying, it does talk about him using drugs at some point, but it also talks about her. She says, 19-year-old Katelyn was regularly doing heroin, so I was getting it from the clubs, from dealer, and that's what I was doing regularly. Needles, I was sick a lot. It's a terrible drug. She talks about it. Yeah.
Yeah, that's fine, Judge.
To redact.
I mean, I still don't think, this is not the last time, she's gonna talk about this a lot more, and she's gonna talk about it in relation to things going on at that time, so I maintain my same, I think her entire heroin use is actually a lie, and it needs to stay in, so that the state can show she's lying.
We make the same argument, Your Honor. It's not relevant. This is not a heroin or drug offense, so we would like that to be redacted.
And I just, from that standpoint, I do want to argue, it's ironic because it's a lot less prejudicial for what they want it out for, because I'm not saying she's this heroin addict, dislike her because she's a heroin addict. I'm saying she's a liar. She's not a heroin addict, and she's using that to it. So it really isn't prejudicial in the way they are arguing to you it is. It's prejudicial in the way that, like, I'm going to say, no, she's not, she's lying. But that's not a reason that something shouldn't be admissible. But, so
It's irrelevant, and it's not relevant.
it is always relevant if the defendant is lying in their statement. And it really just always is.
Understand, but I'll allow him to redact it, but let's make sure what we're talking about. From, yep, it's the world we live in now, is the last line that's played through, so it was smoke, needles.
I think it would be,
What do you?
I mean, I think we don't even need to talk about the end of the victim smoking weed, which is what the next conversation is, so it might as well be until, I mean, well, then she goes on to keep talking about it, her heroin addiction. It was every day, some like occasionally, multiple times a day problem. And then really into the next page. Well, I'll say this, I would need it to stop somewhere at the bottom where she's talking about, where maybe MJ says, okay, anything else at the time? Or we could even say, was it pretty much alcohol, or start it there? Because here she says, on the top of 45, she says, I'm not a heavy drinker. Had a couple of shots once in a while. There are messages that she has with other people who are investigating this case where she says, I was blacked out drunk all the time. That's why I can't remember anything to tell you, because I was drinking so heavily at the time. And even references, again, the drug use and stuff like that as the reason why she cannot explain to them the details that they're asking her. And that is very relevant and probative, especially in light of the fact that later she's going to talk about how she dismembered this body. So I need that to be able to, for a jury to adequately assess her credibility as a liar. She's lying backwards and forwards about drinking. She's telling these people, I didn't really drink much. And then she's turning around a couple years later and telling other people investigating, I was blackout drunk, that's why I can't remember anything to tell you. That is something a jury should know. So I need to leave in, I need to stop at least before the alcohol part about the heavy drinking, because she's going to say that she was a very heavy drinker later.
So you are saying,
So I would,
although you have objection to redacting any of it, your stronger objection deals with down to the bottom of 44 where it's okay, anything else at this time. That's where you're saying the redaction should end.
yes, basically I think it should start with, like, was it, what about alcohol? I mean, were you a drinker back then? And kind of right there we can start it back. And I think that will transition from the GPS thing. They can go to, yep, that's the world we live in now, to what about alcohol? And I mean, it might be a little bit, it might be obvious of a jump, but I think that's really the logical way to deal with it. I mean, alcohol is really not as prejudicial as.
And what are you all asking to be redacted?
Brief indulgence, Your Honor, I just want to quickly. Your Honor, think we would like to keep that redacted, and it kind of goes in the same line of our argument for the drugs. Again, one, we don't think it is relevant. If the state obviously wants to argue that she's lying, the first argument is that we don't believe that this specific part has anything to do with the actual incident. It's one thing if, again, if she was saying in her statement, I wasn't drunk or I wasn't drinking at the time this happened, but the drinking here that she's referring to has nothing to do with the time that this incident happened. So I don't think, again, I don't think it's relevant. I don't think it's just not relevant, Judge. It doesn't play any role in the exact moment or around the time that this happened. I think there are other ways that the state can show that she was lying, given that the statements are inconsistent at moments, Judge. But in terms of bringing in whether she was a heavy drinker or not, Judge, I don't see how that's relevant, especially given that this is not a alcohol related, or there's nothing to suggest that this was a alcohol related incident. There was nothing done. There's been nothing provided to show that she had any alcohol in her system on or around the time this incident happened, Judge. So we would ask that it be redacted as well.
All right. What I'll allow to be redacted is on page 43 from RD, where RD is speaking through the bottom of page 44, where KG says veg out, but then I'll allow the MJ, okay, anything else at that time
Okay.
to come in.
Yeah, just to be clear, the RD that you're talking about, is it where he says, so y'all go, you go get her? I believe that's the second to last time he speaks on page 43.
I'm sorry?
When you mention RD, are you talking about the time where he says, so y'all go? I believe it's the second to last time he speaks on page 43.
Where RD, at about 2/3 of the way down on page 43, RD, so y'all go.
Correct, yes, sir.
You go get her and come back and you stop somewhere.
That's what
Redact from there to the next to the last comment. KG's last comment on page 44 is redacted.
Yes,
And
sir.
then we'll pick up again with MJ. Okay.
The next one I tabbed, that's another one for the defense. I think that they, so when they're talking about heroin, and when you use heroin, what kind of mood did it put you in? You know, it would have made her happy. It was an escape, euphoric. And she talks about it in the beginning of the next page, nausea that comes after, feel shaky. Got on it while I was in Georgia. Smoked cigarettes before. What got you on heroin? She says the co-defendant. She thinks she hid it really well from his parents. Hold on one second, you guys. I think they talk about it all the way until really somewhere at the bottom of that page, we could redact until then, because I think that's when they finish talking about it. She talks about it basically until RD says, yeah, I know, I can imagine, right? I can imagine. And then she talks about my own mom, his mom was different, so I think it's essentially somewhere from RD asking, so let me ask you a question on 52 until
Mid
somewhere
RD
that's
and
logical on
mid
the next
52
page.
through
Her talking about, I mean, there's not a great logical jump in there, but, I mean, we could really go all the way to 54 if we need it somewhere logical, because of her talking about appearances like that. Relevant. So you could start on the next page when you go back to in the driveway, when they're asking maybe on 54. So maybe from RD, so let me ask you a quick question on page 52 to, so when you got back by MJ on 54. My suggestion.
That works.
okay, so make sure I understand. says, so let me ask you a quick question. So you said earlier you know what you used, and then through page 54, where the last redacted line is RD in the driveway acting erratic.
Yes, sir.
I think a little bit before that, probably right after RD, they really are, because I think MJ and RD are talking over each other, saying, so when you got back to in the driveway, and they're just talking about the incident again. So I think the second line on that page would be fine to redact until,
Okay.
just so that, otherwise it's just
RD,
gonna be very.
they really are, yeah.
That's fine, Judge.
All right.
Alright, the next one is page 126. I actually just, and I think I talked about this with you, Mr. Olaloya. Okay. And page 126, I was gonna stop it right here when after they're sort of done talking about the phone passcode, because from that point through the rest of this interview, and actually even into the entire next interview, that's interview with Katelyn Goble 8/2/2023 part 2, they're not really talking about anything relevant, not anything that hasn't already been discussed. In fact, what really happens is her and a different officer go in a room and smoke cigarettes together for like a couple hours and talk about all kinds of things. I mean, they talk about some things that would be helpful for me about her love of mortuary science and all these things, but they talk about some things that are also just like, my kids might go into defects custody and here are all my health problems. It's really not very substantive, so I think we're in agreement to just kind of stop it there and all of us save ourselves a few hours of our life.
So, Your Honor, when it pertains to, you said after stop, is that 126?
Basically the bottom of 126 and then the rest of it and then the next one too. Like the whole part 2 where her and Jamie Bauer or Jamie Gross are just sitting in a room smoking it.
Can I have a moment, Your Honor, just to review?
Sure.
we're fine with the rest on this page. We're looking for something specific on, I guess, the second half of the interview where it says 8-23 part 2, Judge. But everything from page 126 on this specific packet, we're fine with.
Okay.
There's some things in here, Your Honor, in part 2. Can you hear me? I'm sorry. There's certain things in part 2 that we want in. To my motion that we withdrew, that the state brought case law, they're trying to admit her cosplay, her TikTok stuff, where in this interview, she explains it because officers question her about all of this. We want that in.
All right, well, I suggest this then, because the cosplay part is right above the part that we actually really want in too, but I just was kind of like, this is not worth it for the tiniest kernels of information. So if y'all want that, maybe we can just do you have timestamps on that?
Yeah, I think that TikTok is at about 29 minutes and 15 seconds. I don't know what page it
You know,
really
page
is,
it up.
but maybe this is something that we can workshop. a
Maybe
little
we
bit
can
more.
figure out just a
That's
portion
fine.
y'all want and a
I love
portion
that
we want
timeline.
and like.
That's fine.
shorten it.
Okay.
We can do that. Because it's just, I agree, there's little tidbits for us and
Right.
maybe we can just, yeah, because it's a lot of.
Okay, we'll just take the 8-23 part 2, we'll reserve for you all to talk.
Y'all
Yeah.
tell us which part of the conversation, timestamp wise, you want. If you
Okay.
can do that by like Sunday,
I
so
can,
that,
I can do
okay,
that.
then we can, we'll tell you ours.
I timestamped it, I just gotta go through all my notes, but I'll do that to you by Sunday.
Okay, okay. Okay, so then that brings us to the one, the last one in Peoria on 8/3/23. Page 44, she just says, he's like, he didn't have a job, he had a dope habit, how do you feed his dope habit, and he stole AC units. It's the bottom of 44 into the top of 45. And I definitely would stop it right there before she said, like, he never told me about anything violent that he had done.
Yeah, you're right. We're fine with the highlighting from 44 to, I guess, the highlight part of page 45.
Okay?
And then on page 58, I suggest ending the interview there, like kind of 2/3 of the way down on that page, somewhere around like, people do need to be held responsible, yeah, that kind of thing. We can play the rest. The conversations she has subsequent to that are like about her mother and her ex-husband David Settles getting in a fight, and they ask a lot about if they think that, which they've already asked about, if Warren would do something like this again. They talk about his diagnoses actually, and sort of a lot of juvenile court stuff involving him that is certainly prejudicial and inadmissible, and I don't think there's anything in there that even is.
Yeah, I don't think so. We're just looking through just about, I think we agree with the statement this one.
Okay?
We're just going through one final time, Judge.
Sure.
So let me get this, you said you just want to redact where your sticky note is?
Like somewhere, yeah, wherever's a clean ending point, maybe after she says yeah or something, assuming that that's easy to understand, yeah. Like before she starts talking about it, actually hitchhiked with another trucker who was going to Arizona, and all this stuff she's talking about happened in like after this murder and so on. then the last two interviews that need to be redacted, a lot of it's just pretty redundant, but I'm assuming you like any glaring prejudicial issues.
This is the last one with,
The last two, both of them, the one on August 16th and the one on August 20th. And she's back here in Newton.
Yes, Your Honor, I think we agree with the statements.
Okay?
for both of them, Your Honor, nothing stuck out from my notes, so we're okay with that.
We're good, Judge, yeah, so we're fine with
Okay.
with that.
All right. Anything else we need to take up before Monday?
Nothing else? Everything else just between the state and ourselves, but I think for the most part, we've ironed out pretty
All right,
much.
yeah, you all look at that other thing and you can just email me, that'll be fine. I think y'all have my email from the.
Yes, sir.
Meeting. What I wanted to make sure about is in terms of, the process here on Monday, jurors will come into a jury room, okay, and they will be qualified there with respect to residence, or do they just assemble and you get them in an order and then I'll call for 48 up here?
They will have qualified as far as residency, things of that nature. There may be certain things that possibly come up, but for the most part, if there's an automatic disqualification, that will have already been taken care of.
Yeah, police officers, post-certified people. I don't know, do you all take that up downstairs or do we take that
I
up
think
here?
they normally bring it into the
Okay,
courtroom.
fine. I think I asked this earlier, 2 alternate jurors.
I think at least two, I'm more comfortable with three probably.
Okay, I mean, listen, we got all the jurors here, let's, 3's fine.
I think in this type of matter, 3 would be.
And,
And
all right, I'm looking over here, 12 seats, where do the alternate jurors normally sit? In the box, or, because I think the guy with the camera over there probably needs to know too.
I think there's 14 seats there, I could be wrong. And
Yeah,
then they
there's
14.
usually put
Add
one chair kind of where he's sitting right now.
So we'll need 15. We need 3 extra chairs. All right.
No,
And-
I think there are 14 right there.
We
We just
need one
need
more.
one extra.
So I think we just need one more.
Okay, 14. Okay, great. So we need 1 chair. And, this is way ahead, but I'm assuming in the end, silent strikes back and forth will have, the 36 qualified, 9 and 9, 18, 36. What I'm trying to get to is when we get, do you all normally start picking your alternates wherever you ended when you got 12, or do you have a separate alternate panel? And it matters not to me, I've done it both ways.
Usually, if parties agree to use strikes straight through, I've always had a judge who's comfortable with that, but if you don't, then we go to the alternate panel. I'm fine using strikes just however you want. You have all your strikes and use them, and so our alternate panel would just be to the end of how many qualified we need, if that makes sense.
We're cool with that, Judge. The only thing I would ask is if there's anyone that we need to get rid of for cause, would you want us to do right then and there, or wait?
If there's somebody to do for cause, we'll do that after we've gone through everybody. I mean, I may give you an indication that, yeah, that one's, I'm probably gonna excuse that one for cause, so you don't have to spend a lot of time questioning questioning them again, but I hesitate to excuse jurors for cause, starting a deluge of excuses for
Right.
cause.
Right.
Excuses for cause.
I just want to be, because we've had plenty of trials like this, some judges say do it during, some judges, if we wait until after, they say we waived our right to do it, so I just want to make sure
To do what?
for cause, like if we waited till after it was time to do everything, some judges.
If you would, if you think you are going to ask to excuse a juror for cause, if you just alert me that,
Potential.
Judge will be making a motion for cause, and just let me know, and that way I'll be aware of it, but you don't have to do anything more than that.
That's
Thank you, Your
fine.
Honor.
And so,
And what I like to do is, the clerk will have the jury list, correct? And so when we have when I think we got 30 qualified, we'll talk about that, and then we will need, 9 for the alternates?
yeah, 39.
Yeah, so that we have a separate panel of 9, so we'll need 39 qualified, and when we get the 39, we'll go over here are the other 9 that are qualified, and then give you your 15 minutes, and then you start with one, I guess, however you all say accept or strike one or whatever it is.
So
I'm
we're doing
assuming you all
standard,
are aware of it,
like,
and.
out loud standard strike, not silent strike, like we're doing it.
Yeah, so, no, I prefer you just put, we'll have I'm assuming a jury list, and if you accept a juror, you can put an A by their name, and you can put A, and so that way we've got juror number 1, and I'll depend on you all to let me know when we get to 12,
Okay.
and just, Judge, I believe we have a panel of 12, and then we can reorganize, because I want to know, and then you all need to know, and then I'll know we're moving on to the 9 for the alternates.
That works.
We have our forms here, and we'll write like S1 if it's our strike, or if we have no strike, we won't write anything, we'll pass it to y'all.
That's how
You can
we're
either
used
write
to that.
D1, or if you don't, write J1.
So is there like a
in the middle of it.
middleman that has to work?
Yeah, and
Okay, perfect.
we're gonna make Sandra, or do you?
That's
And
fine.
if you accept and you accept, then someone will write a 1 by it, so we'll know we have juror number 1.
Perfect.
Perfect, Judge.
Last question, Your Honor. To pick the jury, do we do panels, or do you want everyone, or everyone?
I prefer everybody out there, and you ask away, ask your questions, whatever they are, and to me, it's much more efficient. It makes sense to the jurors. Selecting panels of 12 doesn't make sense to me or the jurors.
I appreciate that, yes, okay, good. And-
Which is going to kind of limit the audience, I guess, as far as bailiffs are concerned. If there's somebody that's here other than media that want to observe, then we can put them in the jury box over here and let them watch what's going on out there. I'm not sure how they have done that normally, but
We can do that. We also have we have WebEx going, so people hopefully would be okay with watching it,
okay.
even in a computer room. But if not, we usually put them in the jury box until we're striking the jury, and then they have to figure it out.
If someone vehemently objects to having to watch on WebEx, we can put them in the jury box. Yes, ma'am.
We also have, number cards for jurors, if the judges will do that based on their preference or the judge's preference, or they want to do names or numbers during jury selection.
Okay. Names, numbers, I don't.
I'm sorry, say that
What do
again.
you mean?
I've got the number cards from like Judge Foster's, sort of packet, so it's whatever y'all want. If y'all want numbers, I can get those for Monday. If y'all want to do names.
I'm really fine with numbers or names. I just want to confirm we're not having court TV here for 1 year, right? Otherwise, we definitely would need numbers, or any.
Yeah, I don't want jurors identified in any fashion.
Right.
I would
So
ask
I would
that
ask not for
that
board
it not
diet.
be.
So as long as they're not here, names are.
Yeah,
anything
I
like-
mean, you're not gonna be here for 4 hours.
No.
Okay,
Yeah, then.
it's not an issue.
Then it doesn't matter. Whatever y'all want.
Names or numbers, so whatever you're
I mean,
comfortable
we
with.
want you to be here whenever you want to be here, but it just has different problems for
A
us.
room full of jurors, no thanks.
Okay. never show that on Perry Mason either, or, nobody, I think the only time it's, ever been, an issue was in My Cousin Vinny, where they did show the board hour, which was kind of hilarious in some places. Which, what, Monticello, how far is that from here, 50 miles?
Oh, not even, it's probably,
It was-
what, half an hour?
Part of it was filmed in Monticello. If you look close at the road signs, they are Georgia. It's not, the storyline is Meacham County, Alabama.
Right.
But if you look closely at the road signs, they're Georgia road signs. It's the map of Georgia on there.
I
Anything
have-
else?
I have just a question on clarity too. So we'll call in, you'll do the statutory questions, we'll both have a chance to ask our general questions, and then we'll certainly be asking some that I have a feeling will require sequestered for at least some people. Do you want us to try to go about after general questions, individual questions, and then if people feel like they can't talk about something publicly, then we can add them to a list and at the end.
We can address that.
Okay.
Yeah.
I just want to make sure.
I'm assuming those types of questions where, have you ever been the victim of a crime, and they,
Right, yes, I mean, I think that there's some about domestic violence, sexual assault, things like that, but sometimes people are fine talking about it publicly, and sometimes people, need to, yeah, okay.
anything else?
Good, Your Honor, thank
And,
you.
9 o'clock, 10 o'clock, I don't know that I've ever seen a calendar that I know what time we're supposed to convene.
I'm not very.
The jurors have been summoned for what time?
How much time do y'all think you need to get the jurors together, I guess, is kind of more of the
I
question.
need to check and see how many they're actually bringing in. Sorry, I didn't.
I think it's 225.
Probably, yeah. I generally think that they usually have them in and ready, like probably around 9:30ish.
Okay.
Can we do 10 then, I guess?
What time?
Usually by 9:30, if not before then. I feel like that saves as far as when everybody
Let's
can.
go, let's go. Why are we gonna wait?
It's fine, I'll be here at 8, so,
I think 9:30.
yeah.
9:30, that's
I'll be
fine.
here at 8.
But I realized the jury summons that went out to the jurors said for them to be here at 9.
I think it said actually
It's
8:30.
8:30,
It's
okay,
8:30.
well, all right. But you'll have them ready at 9:30. Well, we will just hope to start at 9:30. So you all, and like I say, I'll be here if there are matters that we need to take up before then, we can do that. Did you motion at me for something? Did you have something to say?
I had about 5 people talking at one time. Asking for everybody at once, please,
Well-
that was it.
Well, we were told you would be able to handle at least up to 7.
All right.
Just alert me when that occurs, and I'll stop talking, and we'll stop everybody else so that you can take it down. I did want to ask, bench conferences. If we have to have bench conferences, will your client waive her presence at bench conferences? If not, my preference is we send the jury out. I don't talk in a low enough voice for the jurors that are 10 feet away from me to be able to hear. I know what I'm saying, and more than likely what you all say.
Well, she'll wait, Your Honor.
Okay. All right. You understand what it's where we come up here. They'll be able to tell you everything that's said, and if you have a question about it, tell them to stop me, and I will send the jury out, and we'll deal with it. Okay? All right. All right. With that being said,
Thank you, all right.
Thank you, Your Honor.
we adjourn till Monday.